The Trump administration has teamed up with a total of 25 states to back a major legal battle against blanket bans on concealed carry, a case that's now landed at the steps of the United States Supreme Court. Interestingly, it looks like the state pushing the restriction may have just shot its own legal argument in the foot. Let's unpack exactly what's going on. But first, if you enjoy this kind of deep dive Second Amendment coverage and want to support the channel without spending a dime, go ahead and hit that subscribe button. It helps tremendously. And if you drop a positive comment below, it tells the algorithm that content like this matters and should be shared with more freedom-loving folks. Now, for those of you watching from places like California, New York, or Hawaii, this update could directly impact your rights. We're talking about the case known as Wolford versus Lopez, which is currently seeking emergency intervention from the Supreme Court. This legal challenge targets a recent ruling from the Ninth Circuit, which upheld state-level bans on concealed carry in broadly defined public spaces, claiming such restrictions still fall within the boundaries of the Second Amendment. Here's where it gets interesting. The Department of Justice, yes, under the Trump administration, jumped into the fray and filed a formal amicus brief urging the Supreme Court to take up the case. Their argument? That it's long overdue for the court to strike down concealed carry restrictions that clearly ignore the precedent set in the Bruen decision. Following this move, 25 states and numerous pro-Second Amendment organizations added their support. As a result, the state of Hawaii had no choice but to respond to the growing pile of briefs now sitting before the court. Hawaii's reply basically boils down to this. They say the Supreme Court shouldn't intervene just yet. According to them, more fact-finding and legal wrangling needs to play out in the lower courts before the justices weigh in. But here's the kicker: those arguments completely contradict what Hawaii previously claimed in front of the Ninth Circuit. That inconsistency could end up backfiring in a big way. If you're just catching up, here's the backstory. This case challenges Hawaii's post-Bruen law, known as Act 52, which severely tightens the state's concealed carry rules. One of the law's more controversial aspects? It assumes that carrying on private property that's open to the public is illegal unless the property owner specifically gives you permission. This creates a guilty until proven innocent framework that directly undermines the Bruen ruling. Let's not forget Hawaii wasn't exactly a model of gun rights before this. Over roughly 18 years, the state issued only a small number of concealed carry permits statewide, and in at least one county, 0 permits were granted during that entire period. Now, with Act 52, things have gone from bad to worse for lawful gun owners. As a result of these aggressive restrictions, the plaintiffs, alongside 2 pro-Second Amendment organizations, filed a lawsuit against the state of Hawaii. The federal district court initially responded by issuing a temporary restraining order, which later evolved into a preliminary injunction. That ruling temporarily blocked Hawaii's controversial private property restriction, with the court concluding that it likely violated the Second Amendment and failed to align with the Supreme Court's Bruen precedent. Eventually, the case climbed up to the Ninth Circuit Court of Appeals, where it was joined by a similar challenge involving California's concealed carry rules. When the Ninth Circuit reviewed the case, they reversed the lower court's injunction and upheld Hawaii's sweeping property-based carry ban. The court leaned on outdated laws involving hunting restrictions on private land to justify the modern-day ban on public carry, a legal stretch, to say the least. After that ruling, the plaintiffs petitioned for a full en banc hearing, asking a larger panel of judges to overturn the decision made by the initial 3-judge panel. That request was denied. However, not all judges agreed. Judge Van Dyke issued a strong dissent, arguing that the Ninth Circuit was once again ignoring the Constitution and insisting that the en banc panel should have reviewed the case. Now, with nowhere else to turn, the plaintiffs are seeking emergency review by the United States Supreme Court. It's a steep climb since the case is still in the early stages and doesn't involve a final ruling. The High Court typically steers clear of jumping in this early. Historically, the Supreme Court has declined to hear other Second Amendment cases at the preliminary injunction phase. However, this time there's a twist. With support now coming directly from the United States government under the Trump administration, this challenge has gained serious weight. In their recently filed amicus brief, federal lawyers didn't mince words, declaring Hawaii's near-total carry ban to be flatly inconsistent with Bruin and the historical tradition backing it. They emphasize that Bruin clearly established the right of law-abiding citizens to carry firearms in public for personal protection. One striking aspect of the government's brief was its direct appeal for the Supreme Court to step in right now, despite the case being at an interim stage. That's unusual, given the court's general reluctance to intervene before a final judgment. But the brief highlighted a major inconsistency. Hawaii previously argued before the Ninth Circuit that the record was fully developed and no additional evidence was necessary. Now, in front of the Supreme Court, they're claiming the opposite, that more facts are needed and it's too early to decide. This contradiction has become a pivotal point in the case, making Hawaii appear to be playing legal games to avoid a reckoning at the Supreme Court. In response, Hawaii fired back with the standard anti-gun playbook, arguing that the case is premature, insisting more trial-level development is needed, and claiming that no major legal disagreement exists across circuits that would warrant the Supreme Court stepping in. They even tried to discredit the Trump administration's involvement, calling the federal government an uninvited guest in the case. In its latest filing, the state of Hawaii tried to downplay the involvement of the federal government, stating, "The United States uninvited amicus brief does not alter the equation," while simultaneously arguing that the court should still deny cert because the appellate court supposedly didn't get it wrong. But in the very next breath, Hawaii turned around and said, the United States didn't even address the second question presented, claiming that silence somehow strengthens their position. So, in essence, Hawaii is saying the federal brief shouldn't matter unless it benefits their argument. You can't have it both ways. Hawaii also stuck to its claim that the case is too early for the Supreme Court to review. The problem is, that stance directly contradicts what Hawaii previously told the Ninth Circuit, and that contradiction may have just blown up its entire position. The plaintiff, Mr. Wolford, pointed this out clearly in a recent filing, stating, Hawaii argues that this court should deny certiorari because the record is incomplete. Yet that claim cannot be squared with what the state already told the lower court, that no further factual development was necessary. At oral arguments before the Ninth Circuit, Judge Schroeder asked Hawaii's attorney directly, "What's left to resolve in this case? What more needs to be litigated?" And Hawaii's counsel flatly responded, "We don't believe there's anything left. At the end of the day, we don't see any Second Amendment violations here." That's not a casual statement. That's what's known in legal terms as a judicial admission. It's binding, and the plaintiffs argue it should be treated as conclusive. The plaintiffs went further, calling out Hawaii's attempt to use its own territorial history as justification for its carry restrictions, claiming that because it's been limiting the public carry of firearms since the year 1852, its policies are valid under the Second Amendment. But the reply brief shut that down hard, stating, Hawaii errs seriously in claiming that its local tradition supersedes the national understanding at the time of the founding. That idea is plainly absurd. So the crux of the matter is this. Hawaii already told the Ninth Circuit on the record that no trial or additional evidence was needed. Now that the case is in front of the Supreme Court, Hawaii is flip-flopping, arguing that it's too soon and more lower court proceedings are required. But you can't make one argument to one court and then turn around and say the opposite to another. That inconsistency is glaring, and the Supreme Court may take notice. With the federal government under the Trump administration now backing the challenge, Hawaii might have walked itself straight into a legal trap and torpedoed its own defense. A big chunk of its Supreme Court brief is dedicated to arguing the case needs more development, but again, they already admitted none was necessary. Where this goes next is up to the justices. We'll be keeping a close eye on how things unfold in this major concealed carry showdown now pending before the Supreme Court. And as new developments come in, I'll be sure to keep you all updated. As always, I appreciate you tuning in. If you haven't yet, make sure to like the video, drop a comment below, and subscribe to the channel. And remember, this country was built by informed citizens, and it's going to take informed citizens to preserve it.